Thank you so much for being here. And today we're talking about Contracts 101 for AI entrepreneurs, how you can build and legally protect your business without paying the $20,000 retainer upfront. Just a little bit about me. Who am I? My name is Tatyana Gray Etkin. I generally go by Attorney Tatyana. My undergraduate degree is in computer science, which I got in 2002 here in the United States from Brigham Young University. Originally, I'm from Russia, so people wonder about my accent, so I like to kind of get it out of the way at the beginning. I came to the United States to go to college and then stayed. And so I studied computer science. While I was at the university, I started working for a Fortune 500 company as a software developer, then stayed on full time for a little bit before going to law school. Went to law school, graduated in the top 10% of my class, and then practiced in Utah for a number of years, then took some time off to raise my kids, and then got my license in Idaho recently. So I am licensed in both Utah and Idaho, and I'm an actual practicing attorney. I don't just play one on YouTube. I founded my own law practice called Summit Legacy Law, which is traditional custom legal work. It's basically what you think of lawyers. That's Summit Legacy Law. But then I wanted to do more. I wanted to serve more people with my tech background, seeing all of the excitement going on in the AI space. And some of my clients going that route, I wanted to serve more people and offer a solution that was more affordable and just more modern, kind of in line with the AI space. So I started BusinessAttorney.ai, which right now is just a coming soon page. We're going to launch here shortly within the next couple of months, which I'm working hard on taking a lot of my knowledge and a lot of work that I've done for custom clients and to turn everything into templates that will be not just like your legal Zoom, you get this cut and paste document. It will be automated and using some automation tools. And then lastly, I've launched a school community, an online school community called Legal Launchpad, and I would welcome everybody to join that community. That is really a great place for Q&A. This is actually one of our monthly workshops that I do for the school community. And if you're coming from LinkedIn, I just shared it on LinkedIn as well. But a lot of the action is happening in that Legal Launchpad community. So this is a little bit about me on a personal level. I'm trying to move this. Okay. On the personal level, I'm recently remarried. This is my family. I have 2 biological children that are next to me on that side, whichever side that is for you. And then 3 bonus kids, they're on that side. And anyway, that's just kind of raising family with me and my husband, being busy in the middle of everything else going on in the business. I have to give a disclaimer that this presentation is for informational purposes, and if you need to consult an attorney, please do so. Just have to say that. So we're actually going to have some Q&A at the end. I'm not opposed if you guys have a question right away, just ask it. Raise your hand or just turn your mic on. But other than that, I'll try to go through these slides. I tend to go through the slides fast, so feel free to kind of slow me down. So why trust me? In essence, I'm you. I have tech background. I was a software developer, so I understand a lot of the pains that come with that. And then this newer iteration, even as being a lawyer, but moving more into the tech space, serving tech clients, and also developing technology for my own purposes. I'm getting deep into N8N. I'm getting deep into Zapier, into all kinds of automations, learning AI, not just as a lawyer, but learning it as a tech founder at the same time. And unlike old-fashioned attorneys, I don't believe in lawyer speak or the $20,000 retainers just to get started. Eventually, you probably get there, but I believe that with what's going on right now with AI, so many people are getting into AI and just seeing, younger guys, seeing people for whom it's a second, third career, or maybe even people for whom AI is kind of their last hurrah, but doing it without the legal foundations. So I really believe that we need to help out to as many AI founders as possible. And so I developed this legal protection system specifically because I saw brilliant AI founders building on shaky foundations. And I'll talk a little bit more about this system. And I think for you guys, as many AI entrepreneurs, you get kind of into this dilemma. You're building fast. The AI is like the industry is hot. It seems like everybody is talking about AI, doing something with AI, wanting to sell AI. So lots of people are jumping in. and I'm in several different school communities. I don't know if you guys go to different school communities, but there's several amazing communities that are teaching people to build AI businesses, whether it's an AI consultancy or an AI agency, AI freelancing, doing automation. So a lot of people are getting into this area, building fast, starting to generate revenue fast. But a lot of the founders are relying on ChatGPT or other AI generated contracts or copy and paste contracts that they got from their brother-in-law's ex-girlfriend or something like that. And because, deep down, that those contracts are probably not the greatest quality. You might have fears, especially with your IP. With AI, obviously technology, intellectual property becomes super, super important. So you might be worried about your IP ownership when you hire contractors and developers, other employees, or even with your clients and customers. And you have no clear agreements that define what's going on with IP. And we'll dig down into this whole IP in more details. There's also a lot of fear with compliance and data privacy. I've seen, again, in the school communities, just interacting with different founders, people come in and they're like the acronyms galore, the GDPR, the CCPA, the this and that, and they're just getting immobilized by that. Just the fear of all of these acronyms and agencies and acts and the fear of compliance. They just don't want to go down that route. So that can scare a lot of the newer AI entrepreneurs. And then there might be a deeper fear that somebody can steal your IP, or if you would get sued, what would happen? You can lose everything. You can lose your personal assets if you create an automation for somebody and it just doesn't work well. They lose money, they come after you. So when I was seeing those issues, talking to AI founders about those issues, and the fear of going to your traditional law firm, paying a huge retainer, looking at their website, usually you see like 15 different practice areas. You look at that page and you're kind of, you don't know, where do you go? Where do you start? Who do you need? Which practice area? It seems disjointed. So I try to create a system. I love systems. This is like my tech background comes through. I love systems. And really, I thought that we need to create a system that any AI entrepreneur can come in and see this big picture, kind of zoom out, holistic approach. How does everything fit together? So I came up with this, I call it for now the legal protection system, might come up with a better name for it. But basically, you see that the shape there, that at the center of this system is your business. And then we have 5 pillars plus on top is the legal audit. You have to start somewhere. You have to know where you are before you can get anywhere. And that's what the legal audit is. And basically, it's an evaluation of your business in the other 5 areas. And we look at your entity and ownership, compliance and data, revenue and monetization, team and operations, and intellectual property. Basically, everything in your business should somehow, in legal sense, fit into one of those 5 pillars. And we'll go in depth into each of them. But because this is Contracts 101, I wanted to focus specifically on contracts because they're the building blocks legally of your business. And briefly, we're not going to do kind of like a law school course on contracts, but I think it's important to understand what are the valid elements of a contract. And we always, this is what we learned in law school, offer acceptance consideration. So you have to have an offer, and obviously somebody proposes some kind of a deal. And if you are looking for a client or a customer, this would be your proposal, right? You're proposing a deal, you're proposing an AI implementation, or building an AI agent to your client or customer. If you're talking to a potential team member, like a contractor and employee, then you're making an offer for them to come work for you, right? And then on the other side, whoever you made the offer to, they have to accept it. You have to have an acceptance. And obviously, if it's a customer or contractor, they accept your proposal. Maybe you go back and forth, you make some changes, but at some point, your offer is accepted. If it's an employee or a contractor, the same. You make them a proposal, an offer to come work for you. Maybe you negotiate a bit, then at some point they accept. And then for this to be a valid contract, there has to be a consideration, an exchange of value. And obviously, if you have customer or client, you provide some kind of service or a product, and they pay you for it, they agree to pay you for it. With an employer or a contractor, they provide services for your business, and you agree to pay them for that. So there is a monetary exchange. What I see happening right now, I don't know if you've experienced that, a lot of the AI gurus, a lot of the mostly guys, there's some women out there who are teaching others how to start an AI business. This is a very typical thing that they teach. Go find somebody to do something AI related for them for free in exchange for a testimonial. And I've been offered by lots of people, can I build you a chatbot for free? I want a testimonial back. So even that can be a valid contract, a valid agreement. If somebody offers to build you a chatbot for free, so there's no monetary consideration, but they do want in exchange a testimonial from you. So that the testimonial on your end is this consideration. Or if you're approaching somebody with kind of that type of offer, this testimonial can be a valid consideration to create a valid contract. And then you have to have meeting of the minds. And that's where I'm saying maybe you have some negotiation, but your minds have to meet on something. The other party can accept your proposal as is, or again, you might negotiate a little bit and come up with something slightly different, but you have to, document this meeting of the minds. And usually that is a signature of some sort and a written contract. Because your DMs, they probably won't hold up in court. I wouldn't want anybody to go to court and try to prove that there is a valid contract because there's a string of DMs or emails. Once you have the meeting of the minds, then you want to reduce it to an actual agreement, not just like I said, a string of DMs or string of emails. You want to have an agreement, have it e-signed, DocuSign, there are other services, but have it validly executed. Some of the key clauses that every good contract should have. You want to clearly identify all of the parties involved. And this goes to the liability. In some of my other talks, I talk about business formation and why it's important to have an entity and not operate as yourself as a sole proprietor. You want to separate liability from your business and separate your personal assets. We'll talk about it in a little bit in a couple minutes, but clearly identify the parties. You want to make sure that you're not entering into this agreement individually or as a sole proprietor. You want to have a business entity, either an LLC or a corporation, that shields you from personal liability for whatever might happen in your business. So you want to make sure that it's your business that is entering a contract, not yourself personally. Whether you are providing services or hiring somebody. And this is where, again, the DM or the email can just be a bad idea, because on the DM, if you have your Instagram account, for example, and it's your personal brand account, and then you have an agreement with somebody, really the court can see that you entered into that agreement personally, individually, and you can put all of your personal assets at risk if you do it that way. If you reduce it in writing, you have to make sure that you specify that it's your business that is entering into an agreement, and then you would sign on behalf of your business as a manager or as an officer of your corporation. So clearly identifying the parties is important. And the same for the other party, the counterpart to your agreement. You have to understand, is this an individual? Is this some kind of entity? If it is an entity, does this individual have the authority to be signing on behalf of the entity? You want to specify governing law. Of course, if you're the person, if you're the AI entrepreneur entering into this agreement, you want this to be favorable to you. You want to pick the law of the state where you're operating. And that might be, again, a bit of a back and forth. If you're in, like me, in Idaho, your client is in Florida. Just whoever has the more bargaining power probably would get their governing law put in there, because you would want Idaho, the other person would want Florida. So this is a point of negotiation. You want to have clear dispute resolution provisions. Nowadays, we have things like mediation that's available, and some people feel strongly about mediation one way or the other. Some people feel it's a waste of time. Some people think it's great, but you have to, if you like it or if you don't like it, make sure your contract specifies it. There's also arbitration, and arbitration is binding. Again, some people have very strong feelings one way or the other. If you don't choose, then of course you have traditional litigation, and that would be, with that, you would pick your venue and which court. So make sure that you have that dispute resolution addressed pretty clearly in all of your contracts. Limitation on liability. You would get some protection based on the entity you choose, but you also in your contracts want to set some limits. And usually it would be related to the service you provided or the product. Usually you would limit your liability by that amount. You cannot, for all contracts, set the liability is limited to $100. That usually won't fly. And you need to make sure that intellectual property is outlined in your agreement. Again, with an AI business, intellectual property is huge. So basically, all of your contracts need to at least consider, is there intellectual property involved? And if so, what do you want to do about it? So, okay. Those were kind of your basically law school contracts class topics. And now we're getting into each of these pillars in the legal protection system. We're going to start with entity and ownership. And here, as far as the contracts go, you want to make sure that you have a really good governing document for your entity. basically you will be, if you're not a sole proprietor, which is really, you shouldn't be, you most likely would be an LLC, limited liability company, or a corporation. And with that, you would file some documents with your state to register. Usually it's article of incorporation or certificate of organization, but that is not enough. You really want to have your governing document. And for an LLC, that document is called the operating agreement. And for a corporation, the document is called the bylaws. And again, it's very important to identify the parties. And for the LLC, it would be the company and the members. The owners of an LLC are called members generally. And with the corporation, it would be the corporation is one party and then the shareholders. The owners of a corporation are typically called shareholders. They would be the other party. And you can be the only person in your company or the only person in your corporation. You still want to have these agreements to where you as the sole member or you as the sole shareholder enter into this governing agreement for your entity. And I'll focus here on the LLC operating agreement specifically. Some of the important provisions that you want to have in your LLC operating agreement relate to the management structure. Is it going to be member managed or manager managed? And members, again, are the owners. So by default, in most states, if you don't say anything, then your company would be considered to be member managed. Whenever I work with clients, and I just recommend in general, that the manager managed structure is much better. And you can be the sole member and appoint yourself as the sole manager, but you still should consider having a manager managed structure. Again, for liability purposes, you're really separating those two roles, the role of an owner and the role of a manager. And then eventually you can have other managers in your LLC who can be hired people that come in and manage your company day to day, and you remain the owner. So separating those functions is really good. In your LLC operating agreement, you want to have provisions about capital contributions. Usually you bring something to the business when you started, so you just want to make sure that your operating agreement outlines that. And as the slide says here, you can bring in money, you can bring in property, or you can just provide services as your capital contribution. And then it's important to talk about the distributions. What are you getting out of the business? And how profits and losses will be divided and allocated, especially if you have more than one member. If you have partners, co-founders, that becomes extremely important. How are you going to allocate expenses? How are you going to allocate profits? And then transfer of your membership interest is also crucial. What happens if you want to bring in another member, a co-founder? What happens if you have co-founders and one of them wants to leave or becomes disabled or passes away? So you want to think about that and put it in your operating agreement. For a corporation, you would have bylaws, which is your governing document. There are a lot of similar provisions between the two documents. The corporations would have, that's different from the LLC, is the board of directors. You would have to think who will be on your board of directors, what are their duties are, how are they elected. And again, you can be kind of wearing all the hats at the beginning. And then you would want to have officers. You would want to have provisions regarding your officers. What are their roles, responsibilities? What are you going to call them? What are their titles? And what are they going to be doing day to day? With corporations, it's very important to have your shareholder meetings. So you would want to specify that in your bylaws as well and talk about stock issuance. With a corporation, you can have different classes of stock. You might start with just one class of stock, but you have to really document that really well. So this is your bylaws or operating agreement. This is one of the most important documents in this entity and ownership that you need to have. And yes, since we don't have a lot of people, if you have any questions, let me know. I'm happy to pause and answer any questions. I know that was a lot of information. Okay.
No, I'm good.
Okay. Yeah. Keep on going. Okay, so the next pillar is compliance and data. And here we're going to talk about the agreement called the privacy policy. And I'm sure you guys have heard of the privacy policy. Basically, every website you go to, if you look at the bottom, there's the footer, and it has a bunch of like privacy policy, terms of service, might have some kind of disclaimer in the footnotes. So usually kind of goes in the footnotes. And a lot of people think that it's an afterthought. But if there's one thing that you would take away from this workshop today, it's that the privacy policy it's not just for your website or it's not just for your app, it's for your entire business. Even if you don't have a website, even if you don't have an app, you should have your privacy policy still and be able to give it to your clients or customers if everything's done, even if everything's done offline. And the privacy policy, again, it governs your entire business. It's not just a formality. It applies to all the data that you collect from any source, including any client intake forms, if you have software tools, marketing campaigns. Again, this would be unusual for somebody who is high tech AI, but if you do events, if you have like a clipboard with sign up that people can do by hand, you're collecting data. So you should have that included in your privacy policy that you do that. And what happens with the data? You must disclose AI usage in your privacy policy. If you use AI to process customer data in any way, then there's this emerging legal obligation to disclose that in your privacy policy. And then if you fail to disclose your AI usage, that can create significant legal risk. And this is getting into, well, you collect more data than you think. Sometimes you might think, well, I don't really collect any data. I don't have a sign up form on my website. I don't really collect any data. But even website analytics, if you have Google Analytics that tracks your visitor location, that's collecting data. If you have email lists, if you have subscribers to your email list, you're collecting their email addresses. That is collecting data. And again, it can be an opt-in form on your website, or it can be a paper form that you put at an event and people sign up. You're still collecting data. It can be cookies and pixels, and that's pretty much unavoidable. If you're doing any advertising, you're probably putting your meta pixels there, and you're probably using cookies as well. So just beware that you're probably collecting data of some sort, even if you don't think so. So when I work with clients, and what I recommend is that when you're drafting your privacy policy, and here in the United States, we take California as the highest standard, and we draft to California standard. It is in the United States, California, generally has the most restrictive laws, and that is true with the privacy. Their CCPA, California Consumer Privacy Act, is something that is where we look at and use that to draft. And if you're operating a business in the United States, and if you draft your privacy policy to the California standard, then you're probably going to cover 90% plus of requirements of any other state. So it just becomes easier that you don't have to worry about every state where you might be collecting data from. And sometimes it might be worth, if your state is unique in some sort, to have an addendum to your privacy policy that is that state specific. I'm picking on Florida, but if Florida had some kind of interesting data privacy requirement, you might have to have a Florida addendum if you operate in Florida and you just happen to collect a lot of data from Florida residents. And with a California law, it applies to your company's reach, not your company's location. So you might not be in California, but if you reach California residents, and again, if you're an AI business and you're online, you're probably targeting the United States entirely, not just probably your local area. So that is the document, the contract that goes with your compliance and data pillar. And we're going to move to revenue and monetization. Again, you can raise your hand if you want to pause and ask questions. If not, I'm going to keep on going. Okay. So with your revenue and monetization pillar, the contract that we focus on is your client services agreement. It is often referred to as the Master Services Agreement, MSA, and this is your best defense against chargeback and payment disputes and refund requests. This is one of the biggest fears that I see in AI entrepreneurs, again, that I come across in different school communities, the complaints that they do something and then they would get hit with a chargeback. And a lot of the entrepreneurs use Stripe, and Stripe is very customer centric, not business centric in a way. So it is most likely that Stripe would issue a refund to them and a chargeback to you, unless you really have really good chargeback defense kit and you can get back to Stripe or whoever your other processor might be, and show them proof that services have been provided or product has been delivered, that you fulfilled your obligations completely. You might have to provide text messages back and forth just to show that the person received value from you, or if it's some kind of consulting, that the person participated in your training sessions. So there is a way to kind of to fight back on the backside of it, but really the best way to avoid chargebacks is to have a really solid client services agreement. And some of the key clauses that would protect your revenue is a crystal clear scope of work. I like when deliverables are outlined and there are timelines, and if you offer any revisions, you build a tool and you offer several revisions, you say 2 or 3 revisions, and then it helps you so you don't get stuck working for basically indefinitely for a flat fee arrangement. And then if there is a request for a refund, you have your contract to provide to somebody like Stripe, show what the deliverables are, show proof that you've provided those deliverables and that the person is not entitled to a refund. IP ownership of these deliverables is crucial, and we'll get into that on the next slide, I believe. Define whether the client owns the final work product outright or gets a license to use it. And then if you retain the ownership, you just want to make sure that your underlying tools and processes, that all stays yours. And then a strong refund and chargeback policy, just state your refund policy. And if they want to cancel, and what are the terms of that? So if you have some kind of a AI consulting contract and they signed up for a year and pay you monthly, but then they decide to cancel it, maybe you want to say that they can cancel, but then they have to pay you half of what's owed instead of having to pay the rest. Say you have a $10,000 annual consulting contract, and they want to cancel in the middle of it. So they've gotten $5,000 worth of your services, they want to cancel and not pay the other $5,000. You can say something that like you allow them to cancel, but they have to pay you half. So they would still owe you $2,500 and then they're released from the rest. But then you don't have to provide any of the services once they cancel. So here is a common AI founder's trap. And this is a kind of a hypothetical blend of real life scenarios. So meet Jordan, he's an AI entrepreneur. He is fantastic at building agents and he uses N8N. I don't know if you guys use N8N, but it's very popular. I'm sure you've heard of it. And what he does, he finds a free N8N workflow template online and uses it as a starting point. There are also, again, I keep going to the school groups. There are many school groups that the founder of the school group would offer these N8N kind of skeletons that anybody in their group can take and customize and go sell, find clients and basically customize the workflow and sell to the clients. So this is basically Jordan. He gets templates from N8N for free, and then he's going and looking for clients, offering to build them N8N agents. And then he works closely with the client. They develop custom prompts and logic to modify this kind of the skeleton. And then Jordan delivers the final customized agent to the client. And the million-dollar question is, well, who owns what at this point? And without a written contract, the answer is dangerously unclear. And so this is one of the most common mistakes AI entrepreneurs make. And if you were to ask ChatGPT or other AI tool just to give you a customer services agreement, it is unlikely that it would return the provisions that we're going to talk about now. So if you don't have provisions about this, kind of the default is we have the original N8N template author, and that author of the free template, they likely still own the copyright to that original skeleton. They probably released it under a license, and a lot of the times the AI founder just gets it, doesn't read the license, doesn't care about the license, they just see free and think that they're free to use it. There's probably some kind of a license, MIT or Creative Commons or some of them, that would allow you as the founder to use and modify the skeleton workflow, but you must follow some kind of rules. It might be attributions that you disclose that this came in originally from person X. The AI entrepreneur, what he would own, Jordan probably would own the copyright to his original contributions, the specific customizations, any code, any creative work that he added on top of the free template. And the client, what the client would own, this is the biggest gray area. The client might have a strong claim that they own the final completed agent that they paid for, that everything. They can also claim joint ownership of the prompts and ideas that they developed together with Jordan, their AI entrepreneur. So we don't want to leave this kind of mess and let the default be whatever it is if you have to litigate it, it would go to court, and basically it will depend if there's any precedent in your state, how the judge would rule on these points of who owns what. So if you do that, then the result is just nobody has clear ownership. Jordan can easily reuse his custom work for another client. Client doesn't have clear rights to the underlying template. So this is kind of a classic example. We don't want that to happen. So the solution is to have a really good client services agreement where you address these provisions. You want to define what the background IP is. It should say that the AI entrepreneur will retain full ownership of pre-existing tools, processes, the N8N skeleton. So that would be the background IP. If you're the AI entrepreneur, obviously that would be your background IP. You would clearly define the deliverables. What is the deliverable? It would be the final agent created for the client. And then on the IP of the deliverables, there are two common ways to go. You either give client full assignment, something like that language there. Upon final payment, the client will own the final deliverable, and you as the entrepreneur, as the business, assign all rights to the client. That is one way. Another way that is pretty common is to give the client a license. So you can say something like, upon final payment, the client receives a broad perpetual license to use the deliverable, and you as the entrepreneur retain ownership of all of the underlying IP. And this kind of comes to the bargaining power. And for you probably want to just license it to the client, but the client probably would want full ownership. So this is that negotiation. What can you negotiate? And then if you co-created any prompts, then the contract should state who owns the prompts that you developed during the project to avoid any ambiguity. For example, you can say that all prompts, inputs, and strategic materials co-developed by both parties as part of this project shall be owned by the client. That's probably pretty common. I know that myself, if as a client myself, I would want to own any prompts that I've developed with my developer. The bottom line, that a contract transforms potentially messy situation from a confusing mess to a clean professional transaction, protects your ability to reuse your core work while giving the client the rights that they paid for. So that is on the revenue and monetization. Kind of the important contract is this, the client services agreement, also known as the master services agreement. So on some of the most important provisions. Again, I'll pause for a sec. If don't see any questions, we'll move on. Okay, so the next big pillar is your team and operations. And in your team and operations, basically would encompass all of your workers, and I'm calling them workers because some of them might be employees, some of them might be independent contractors, otherwise known as 1099 contractors. As a newer business, you most likely are going to have independent contractors before you have employees, so we'll focus on the independent contractor agreement here as one of the main documents under this pillar. It is essential to have an agreement in writing when you're hiring help. And one of the important provisions there is the IP assignment clause. So we'll see this IP running basically throughout all of the agreements. If you are non-technical founder and you are hiring a developer, a technical developer, IP assignment becomes extremely important. Even if you're a technical founder, I know people who are technical founders initially, but then they get so busy, they run their business, and they don't have time to actually do a lot of the underlying technical work of building agents. So they start outsourcing and bringing other developers on board. So you still would have contractors in your business. You might be technical founder, but you need to hire a VA, a virtual assistant or executive assistant. That person most likely would be a contractor at first, not an employee. And even with that person, they might be generating social media posts for you or helping you with blogs. So creating some kind of materials that you want to make sure that all of the IP is assigned to your business. Not actually, sometimes say to you, but to your business. Again, this is the most crucial clause. You just don't want to go hire somebody, willy-nilly. And I would say that I haven't looked into this, but I would be curious if you hire somebody on like Fiverr or Upwork, any of those platforms, what happens with the IP assignment. I haven't looked at their underlying documents because you're relying on those. But I would say that even if you use a platform like that, you still, on top of that, want to have your own independent contractor agreement where you would make sure that the IP they create is assigned to your business. You also want to make sure that you have confidentiality provisions, NDA, non-disclosure provisions, especially if you have any kind of like secret sauce, trade secrets, and other confidential information, your clients, your customers, their names, their whatever you collect about them, their addresses, phone numbers. You want to make sure that your contractors and employees as well keep that information confidential. Worker classification, we're not going to get into that very much, but like I said, you're probably going to start with contractors who are working for you part-time, either on a project basis or maybe a few hours here and there. But you just got to be careful when they might become an employee, because if you truly have employees and you're still classifying them yourself as contractors and not collecting any payroll taxes for them, you can get severe back taxes and penalties from the IRS if you misclassify your workers. Some other important provisions to have with your independent contractor agreements is to have a clear crystal scope of work. Just like for yourself, when you're doing work for somebody else, building AI for them, when somebody else is doing work for you, you want to make sure the scope of work is very well defined. If it is time that they're working for you, you want to make sure that that is there. If there are specific projects, you want to make sure it's there. If there are any deadlines, if there are milestones, if there are performance expectations, you want to make sure you know what you want from your developer or VA, and they know what you want from them. So make sure the scope of work is clear. The payment terms, very important. What are you agreeing to? Are you going to be paying this person every other week, once a month, per project completion? Make sure that that is spelled out, so you know that's coming and they know that's coming, so everybody can be happy. And termination rights are very important as well. What happens? Who can terminate? What are the conditions? Is there notice required? Can it be done can it be done at for cause? Does it have to be something that either one of you, the business or the contractor, does, that something is bad or wrong and there's a cause to terminate? And you want to make sure to include some onboarding and offboarding provisions as well. Those are good to have. For developers in AI businesses, founders often have to hire developers. So some of the important provisions to put into your agreements is access control and security. So you just want to make sure, what can they access, what data sets, what APIs, spell it out. As well as code documentation standards. You require that all code be delivered with clear, sufficient documentation. If the person leaves and the new person comes on board, you don't want the new person to spend 3 days trying to figure out what's in the code, right? So from the beginning in your agreement, spell it out that you require documentation, comments, so the code is understandable. And then, like I mentioned, offboarding and asset handover. What happens if that person leaves for whatever reason? We want to make sure that your business gets their code repositories, then that you would offboard them from services like AWS or Slack. So think about that as well. Those are provisions for your independent contractors that are important to have. If you have international developers, this is pretty popular as well, just to hire international developers. Then the governing law and jurisdiction becomes tricky. For you, if you're in the US, you most likely want the United States. If you don't specify anything that the governing law is in the United States, you might have to have a dispute with them on their turf, under their laws of their country. So you don't want that. Again, this can come to the bargaining power, but if you are in the United States and you're hiring foreign developers, you probably have more bargaining power. So this is where it can go into your favor. So you would want to specify governing law and jurisdiction that is very favorable to you. It is pretty common with international developers to request binding arbitration and to do binding arbitration, and then you might be able to negotiate on that. Then you want to make sure you outline what currency the payments are going to be made in. Again, for a US company, you most likely want to say United States dollar and not really worry about their currency. Most developers, foreign developers, are happy to get US dollars, so that's usually not a problem. As far as tax compliance and forms, because they're your independent contractor, you just want to make sure they're responsible for all of their local taxes, and you probably need to get this form W-8-BEN from them. And you would take it to your CPA. I would recommend everybody works with a really good CPA, especially if you're hiring foreign developers. Just work with a CPA. They can help you with all of this tax and forms. And then there's cross-border data privacy. If your developers in Europe, they're most likely subject to GDPR. And even if you're not, and your customers are all really in the United States, but if you're developers in Europe, you still have to worry about GDPR. So just be aware of that. Make sure that your agreement spells out that if they're in Europe, they have to comply with GDPR on their end. This is a fun situation. What if you want to pay your developers in Bitcoin? I had a run-in with that. And so if you do, make sure your independent contractor agreement addresses that. And some of the things I had to learn that you would have to put in your agreement is specify a fiat value. So never peg the payment to a fixed amount of Bitcoin. You don't want to tell them that you'll pay them 1 Bitcoin. You make sure that you do an equivalent, like US dollar equivalent. And then how are you going to be converting? When are you going to be converting and making this calculation? This is the most critical part. And some of the options, it can be the moment that the transaction is sent. It can be a specific time, like the payment due date. So this will be, again, can be tied into what is your responsibility, how often to pay them, when to pay them, or you can use a spot rate from something like Coinbase or Kraken. And so you would specify that in your contract. And then for proof of transaction, your contract should say that the developer's wallet address and that it would be that a verifiable transaction hash on Bitcoin blockchain will serve as proof of payment. So this was some of the fun stuff I was learning at one point, and now I'm passing it on to you. But you can see how this gets pretty complicated and unique. And again, one of the reasons to just not trust a generic template or AI generated contract, because if you don't know to ask this, then the AI probably wouldn't know to ask you that. So it's all based on input, kind of garbage in, garbage out, great input in, great output out. So that is on the team and operations front. Okay, and I know we have 10 minutes and we're getting into intellectual property. Understanding your intellectual property, I'll try to go fast through this. But again, intellectual property is its own pillar, but it kind of weaves through everything in your business. If you are in tech, you're dealing with AI, intellectual property is paramount. And you want to protect your intellectual property. Some of the ways to protect your intellectual property is trademark and copyright. And so trademarks protect your brand identity. It can be your product name, your logo, tagline, and then copyright protects the original creative works. And for, again, an AI business, it can be your code, AI models, website, blog posts, video content, so that you can get copyright protection on that, on the creative works. And your IP is a core business asset. It's not just an afterthought, it's an asset. And it's valuable. You can license it, you can sell it, and it is really critical if you are looking for investment at any point is to make sure that your IP is secure. And for example, you might not think that something like a domain name is an asset, but your domain name is an asset. And what happens is somebody wants to get into the AI and they have a business name in mind. They go register a domain name right away. Like first thing they do, they register that domain name in their individual name. And so that is not your business asset. And if you ever wanted investors in your business or to sell your business, you need to make sure that that asset is in your business, that is owned by your business. So you want to make sure that your domain is assigned and owned by your business, not just by you individually. And with that, it's really good to have an IP asset inventory, just a spreadsheet. I have an example, but you want to make sure and keep track of all of your IP so you know who owns it. And then if you were to start raising money or if you were to sell your business, you have this inventory that you would include as part of your business assets to justify the value. And so the purpose of this inventory obviously is to describe the IP, what it is, verify ownership, identify any gaps. So like with your domain name, you would say domain name, but you realize it's registered to you individually. So you need to do something about it to transfer it to your business and then increase value of the company. And if you think it's like, oh, who cares? I wanted to get the domain name legal.ai. I went to see how much it was, and it was, I think, close to $5 million just for the domain name. So there's a huge value, even in assets like you think might not be too valuable. And what to include in your AI inventory. So you would want anything that deals with your brand and identity, like your brand name, logos, domain names, your creative works. So if you have any models, algorithms for your AI, any software code bases, and then stuff like website content, blog posts, video content. If you have any unique prompts and prompt chains, that's also copyrightable. And then what is your confidential information, like trade secrets? If you have proprietary data sets, customer lists, what is your secret sauce? All of those are your IP assets. And here's a sample IP inventory, easy to create, but pretty self-explanatory. And then what happens if you forgot the IP clause in any of your agreements, or you got your domain name, but you didn't your name? It is a problem, but it's fixable. And so to fix that, you need the IP assignment agreement. And it is one of the kind of core agreements in the IP pillar of our model, of our system. And so you can fix your past work, you can make it retroactive. So you can go back to your contractors or employees or back to your clients and customers and ask them to sign this IP assignment agreement. It's harder to do it after the fact because you kind of lost your bargaining power at that point possibly. So it's best to do it in the actual documents when you bring clients on board, when you bring team members on board, but you can go back and fix it retroactively. And also you want to make sure that it's proactive as well, that anything going forward, that any IP that is generated by your team members, it automatically becomes assigned to your business. And here's the risk, IP risk of AI generated content. It is a gray area, and there is copyright ambiguity. You might not know, depends on the jurisdiction, who owns materials that are generated by AI with your prompting. If it's purely AI generated text or images, that might not be protectable. Again, the bottom line that if it's purely AI generated assets, they're unlikely to be protected. So, and you have to read platform terms of services. They're usually pretty long, but they would tell you what rights you have to the output. And for example, like OpenAI gives you broad rights, but some of the other platforms might not. So where are your gaps? After hearing all this, how do you know where your gaps are? The solution is the Express Legal Audit that I created. It's a personalized risk report that quickly shows you where you might have some gaps. And right now it works. I'll have a link. You use the link, you book some time with me, one-on-one call with me. You'll get an NDA, mutual NDA, so you can feel safe disclosing your information in this Express Legal Audit. You'll fill out an intake form, takes less than 15 minutes. Then you will get your report right away. And then when we meet one-on-one, we'll discuss your report, and then we'll just see kind of what are the action steps, how else I can help you. And this is free right now, so you can book your Express Legal Audit. That's the link, bit.ly/Express Legal Audit. You can do the QR code. For now, that's kind of what I said. If you book it, you get one-on-one time with me. We're changing it, so in the next couple of weeks, it's going to change to where you go do the report first, and then to have a one-on-one call with me would be actually a paid upgrade. So if you want to do this and get a call with me for free right now, do it sooner than later, because like I said, we're changing this process. And then I invite you to join our online school community. It's called Legal Launchpad, and the link is there as well. And what I can do, if you guys want to leave your email addresses, I can send this to you, the links to you through email. I'm trying to think what other way you can take a screenshot of this. But basically, this is the presentation. We have some time for Q&A. We have 2 minutes left for Q&A. So if you have questions, you can ask me now, or you can type them in the chat. I would screenshot that, and then I would just repost your questions and answer them in the Legal Launchpad community. So that would be, for your benefit and for the benefit of other members of the community. So with that said, we have just a short time for Q&A if you have any.